All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is Arizona Court of Appeals, Division 1, cause number CA-TX140001, American Helicopters versus the Arizona Department of Revenue. Welcome to the Court of Appeals. For the party's information, these proceedings are being recorded, both audioly and visually, and hopefully in due course you'll be able to see yourselves on YouTube, if it all works well. As you approach the podium, please identify yourself and who you are representing before you begin your argument. Each side will have 20 minutes for their argument, and appellate, you may reserve a portion of your time. If you'll tell us how much time you want, then we'll try not to horn in on your rebuttal time. We have read the briefs and the relevant portions of the record and discussed the case in conference this morning, so we are aware of the facts and the issues that are before us. And the clock on the podium tells you how much time you have left, including your rebuttal time. So with that, we may begin.
Aaron Morris on behalf of the appellants, and I would like to reserve 4 minutes for rebuttal.
4 minutes. Okay.
May it please the court, the issues or the issue that this case revolves around are two vastly different interpretations of identical language in two exemption statutes. Exemption statutes related to the purchase of dynamic aircraft equipment, and the exemptions exist as to a use tax and as to a transaction privilege tax.
Are we talking just the helicopters?
We are.
Okay, so we're not worried about fixed wing.
Well, to the extent that the exemption would cover both, we are. Nobody has gone to any effort in this case to differentiate between dynamic equipment purchased for a fixed wing aircraft and dynamic equipment purchased for a helicopter. That's not been an area of inquiry in the litigation at all. They've all been lumped in together for the purposes of this case. But really, by and large, when you're talking about the appellants in this case, you're dealing with rotorcraft. You're dealing with helicopters.
So if in fact it's fixed wing, we'll leave that for another day.
Correct, John.
Okay.
The case law is clear. I mean, if the statute is determined to be plain and unambiguous, it's to be enforced by the court in the manner that is provided in the statute. It's the Department of Revenue's position in this case that these two exemption statutes are plain and unambiguous, and it's the taxpayer's position in this case that they are anything but. The exemptions provide, and I understand that there are multiple subparts, and if you have a CPCN, you fall under one category, but really the key language in this case, for the purposes of these taxpayers, is that the exemption applies to a person holding a supplemental air carrier certificate under federal aviation regulations. It's then followed by a parenthetical reference to 14 CFR Part 121. It is the taxpayer's position that those exemption statutes are anything but plain and unambiguous. And the reason for that is quite simple. First, there is no definition provided in this statute or anywhere in the Arizona Revised Statutes that identifies what a supplemental air carrier certificate is. Secondly, if you actually go to federal aviation regulations, there is nothing called a supplemental air carrier certificate. It doesn't exist. Thirdly, the reference in the parenthetical to 14 CFR Part 121 does nothing to clarify the actual language that is set forth before the parentheses, because in reality, no air carrier certificates are issued under 14 CFR Part 121. All air carrier certificates are issued under Part 119. So it's, go ahead.
I was going to say, and I've also seen indications that Part 135 also apply?
Well, and I was going to say, if you actually go to the regulations, air taxi service basically is broken into two categories. Your operation specifications are going to occur under Part 121 or Part 135, and the only thing which determines which operation specifications will apply is what type of aircraft you use. If you use aircraft that have 9 or fewer passenger seats and has a payload capacity of less than 7,500 pounds, you are going to be governed under 135. If you exceed those numbers, in other words, you have 10 seats or more, or a payload capacity in excess of 7,500 pounds, your operation specifications are going to be under 121. And if you are a rotorcraft operator, in other words, if you're using helicopters, you're going to be under 135. But the reality is, if you actually look at 14 CFR Part 119.21 sub C, you will see that a carrier whose operation specifications should be set forth under Part 135 can actually ask the administrator to provide them with operations specifications under Part 121. In other words, and if you actually take the time, as I have, to read Part 121 and Part 135, you will see almost uniformly that they are referenced together. It's basically because really you have operators who are doing the exact same thing. They're just using different types of aircraft. 121 is using big fixed-wing aircraft. 135 is using smaller aircraft or helicopters. And the Department of Revenue advances this interpretation of what a supplemental air carrier, and they admit in their brief. In their brief, they come out and say, supplemental air carrier certificate is a term of art. But they then offer a definition for what it means, but they provide no citation to any authority which would support that. In reality, if you are in this industry, there's basically two spheres. You have scheduled air carriers, Southwest, United, American, and then you have everybody else. Those are your supplemental air carriers. And the easiest way to put it in actual terms that people who are not in this industry can think about, you may fly to Phoenix on Southwest, which is a scheduled air carrier. But if you're going to fly to Prescott, you're going to use a supplemental air carrier. If you're going to fly to Tucson, you may fly on United, a scheduled air carrier. But if you're going to fly to Show Low, you're going to be using a supplemental air carrier. The distinction that the Department of Revenue tries to devise to somehow craft a way to say that this tax applies to people using smaller aircraft or helicopters, but doesn't apply to folks using larger aircraft, to describe it as a term of art, it goes completely against what everybody in the industry thinks. Everybody in the industry would tell you, I'm either a scheduled operator or I'm a supplemental operator. No matter how you characterize, whether it's air taxi, whether it's charter, they're a supplemental operator if you're not working with one of the big airlines.
So it's your contention then that supplementing means you just supplement whatever else is available as opposed to supplementing scheduled major carriers. So in other words, if you, I'll use Yuma. If you fly from Yuma to Phoenix, you'd probably fly on a, what's it called, SkyWest or it's U.S. Air, but they use somebody. They use a small.
The old Frontier used to fly.
And then, but then from Phoenix to Dallas, you would probably fly on U.S. Air. Is that correct?
It's correct with a little correction. You're still thinking too large when you reference a Frontier or a SkyWest. And really, we're talking about probably carriers you don't know the names of, quite frankly. These are small planes. You're talking between 10 seats and 40 seats.
Are they contracted to the larger carriers? Maybe.
In some instances, they would be, but generally, if you're contracting with the larger carriers, you're going to have a CPCN. The reason I bring all this up is because the case law is clear. If this court determines that this is a plain and unambiguous statute, and quite frankly, I can't see how it would, but if it does, I lose. But if this court's willing to look at this and say, yeah, there is no definition of supplemental air carrier certificate in the statute, And I've reviewed all of the federal regulations, and there's nothing called a supplemental air carrier certificate. Therefore, as a matter of law, it's ambiguous. Once you make that determination, with all due respect to the Department of Revenue, I pretty much win the case, because if you actually look at the legislative history that is behind the amendment of these statutes in 2000, it is very clear that the size of the aircraft meant nothing. If you look, and basically you have four things that you get to look at. You can look at the House Ways and Means Committee minutes. You can look at the Senate Finance Committee minutes, and you can look at the fact sheets for both bills. The fact sheets for both bills make no reference whatsoever to Part 121. All they do is make it clear that the whole purpose of these amendments in 2000 was to close this gap created by the Airline Deregulation Act of 1978 to basically extend these exemptions back to their pre-1978 position, which is that they covered everybody who operated, because everybody back then had a CPCN. And it makes it clear that the purpose here was not to differentiate amongst helicopter users and small aircraft users and slightly larger aircraft users. It was just a remedial effort. They even made it retroactive to cover the one operator who qualified at that time under 14 CFR Part 289, which was the Far West Airlines. And if you look at the legislative history, it's clear that they're not dealing with the size of the aircraft. They're dealing with equity. They want to make it possible for the small airlines who are doing the exact same thing as the bigger airlines, but are doing it with slightly smaller aircraft, to have the ability to enjoy the same tax treatment as the larger air carriers. They even reference in the Senate Finance Committee the fact that this is likely to spur economic development in northern Arizona, which is the Grand Canyon, which is where all of my clients, it's their primary point of operations. Looking at the legislative history, and I tried my best to get the Superior Court to do so, and he ruled against me and said, nope, plain and unambiguous, but then his opinion went into all sorts of operation specifications. If we get past that first step and the court says, yes, we're going to look to the legislative intent, you will not see a single reference to operation specifications. You'll even see references to the fact that they acknowledge that although Far West Airlines, which was the party that was lobbying for the amendment, although they were a Part 121 carrier, they were technically air taxi, but still fell within this umbrella of supplemental air carrier. And it acknowledged that this amendment would make it possible for future air carriers who are certified in the exact same way as Far West to avail themselves of the statutes. And that is key, because Papillon and, the taxpayers, all of my clients in this case, were certified in the exact same manner as Far West. They received their certificates from the Department of Transportation under 14 CFR 298. They received their certificates from the FAA under Part 119. They are, regardless of whether they call themselves air taxi or call themselves a commuter operator, it doesn't matter. They're still a supplemental carrier. They were licensed, they were certified in the exact same manner as Far West. Really, the Department of Revenue can provide if you move past this first level, which is this request for a plain language reading of what I find to be a confusing statute at best, and look to the legislative history, there's really nowhere the Department of Revenue can go. There's nothing in the legislative history that supports their reading of this statute that one operator should get some kind of different tax treatment from the other operator based on the size of the aircraft. If the court has any questions, I'd be happy to address them.
So the taxpayers are certified under 298 and 119, 14 CFR 119?
Right. The FAA only issues certificates under Part 119. So whenever we're talking about Part 121, Part 135, those are operation specifications. Those have nothing to do with the certificate that the operator is actually received from the FAA. Those are all issued under Part 119. So yes, Far West received its certificate under Part 119. All the taxpayers receive their certificate under Part 119, and all of the operators are availing themselves of the small aircraft exemption that is provided under, I got to make sure I'm giving you the correct reference there.
Oh, please.
Yes, 14 CFR 298. That's both Far West and all of the taxpayers availed themselves of the small aircraft exemption that is provided under that provision. So their certifications are exactly the same. They're providing the exact same service, just using different sized aircraft. If there are any other questions, I'd be happy to address them. I think we did pretty well in the briefs to try to lay it out for you.
Thank you.
Thank you very much.
I'm Scott Teasdale, Assistant Attorney General, representing the Arizona Department of Revenue. May it please the court. We think this is a very simple case with very simple facts and a very simple statute. The taxpayers are claiming deductions that in order to qualify for them, Papillon Airways, Inc. would have to be the holder of a supplemental air carrier certificate under Part 121 of the FAA regulations. It was not, and therefore these taxpayers do not qualify for the deductions that they're seeking. Nowhere in the department's case do we emphasize the size of the aircraft. That's their case. Our case is the statute, and the statute provides deductions for transactions with a person holding a federal certificate of public convenience and necessity, which they did not, a supplemental air carrier certificate under Federal Aviation Regulations 14 CFR Part 121, or a foreign air carrier permit for air transportation. They don't qualify under any one of those three parts. The only one they claim is they somehow fit into being a supplemental air carrier under 14 CFR Part 121. Now, Papillon is not a Part 121 carrier. It is a Part 135 carrier, and the record is quite clear on that point. Papillon's later acquired Certificate of Public Convenience and Necessity noted that we would consider Papillon's acquisition of larger aircraft would require certification under 14 CFR Part 121 as a substantial change in operations. And they limit their authority to being operating under a Part 135. Now, 14 CFR 119.1b2 refers to the certification requirements an operator must meet in order to obtain and hold a certificate authorizing operations under Part 121, 125, or 135 of this chapter. And 119 is replete with references that indicate that the certificates incorporate other parts in the Code of Federal Regulations, 121 or 135.
Now, I started out at the outset, we're talking about the rotorcraft, or are we talking about fixed wing, or does it matter?
It does not matter, whether it's rotorcraft or whether it's fixed wing. Under our statute, for purposes of the deduction, it does not distinguish between rotorcraft or fixed wing. It is based on whether you are a holder of particular types of certificates or not. Now, the taxpayers are arguing that no certificates are issued under Part 121 and claims that all air carrier certificates are issued under Part 119. Well, if you look at 119.1, 119.5, and 121.2, they all reference certifications under Part 121 or Part 121, 125, or Part 135. It does not matter whether it has issued out of 119, it matters whether it's incorporating these other specifications. The specifications they're operating under are Part 135, not Part 121. Federal statutes at 49 USC 41719 also talk about Part 121 air carrier being an air carrier to which Part 121 of Title 14 Code of Federal Regulations applies, and a Part 135 air carrier means an air carrier to which Part 135 of Title 14 Code of Federal Regulation applies.
Because what is a 121 air carrier?
Pardon me?
What is a 121 air carrier?
Part 135 is titled Operating Requirements, Commuter and On-Demand Operations. And Part 121 is titled Operation Requirements, Domestic Flag and Supplemental Operations. And what are we talking about here? A supplemental air carrier. The supplemental air carrier is under Part 121 when you look at it. There is no part of 135 that references being a supplemental air carrier. Now, what the difference is that 135 are charter operations. When you want to go take a tour of the Grand Canyon and rent a helicopter to do, you call them up and say, I want to come down. It's not a scheduled service. And in fact, the record...
Or to take a helicopter down to the Grand Canyon?
Yes, they basically it is an on-demand service as opposed to your scheduled service where you look up and see they're flying at a particular time, point to point. Now, and again, their own testimony in a different case. They testified Part 135 are the rules we operate under for the FAA. The FAA has Part 121. Southwest Airlines, Delta Airlines that are on a scheduled route. Then you have on-demand 135 charter, which is what we do. That's correct. That is what they do. And unfortunately for them, they simply do not fit within the language of the exemption. Now, if we went back past the plain language of the statute and actually looked...
What is the definition of supplemental in
it is...
context? Because you've said that.
Supplemental, Your Honor, is someone who is operating pursuant to a certificate authorizing them to operate under 121. And Part 121 contains the requirements for operating as a supplemental carrier, which are different from the requirements for operating as a Part 121 carrier. Now,
what does a carrier do differently under 121 as opposed to 135, which is charter? I understand what you mean when you talk about chartering, but I don't know what you mean when you say
Your Honor, the Department of Revenue doesn't look at what they do when they're looking at a requirement that they be a holder of a particular certificate. They simply look at whether they have that certificate. If they had a 121, they were a holder of that certificate, they would qualify doing the same thing, but they didn't have that. And when you don't have what you need to qualify for the exemption during a period, you don't get it. And it's as simple as that. Now, if we went back to the legislative history, we heard a lot that, if you look at the legislative history, we definitely win. Well, the legislative history indicates that Far West Airlines came in and lobbied for an addition to the statute that would cover Part 121 carriers because it was a Part 121 carrier. And in fact, the legislative history that we've cited at IRA 19 states that the Federal Aviation Administration issues certificates. The supplemental air carrier is under Part 121, which is charter or cargo, and most of the small airlines in Arizona are under Part 121. All right, most. They didn't say all. And when they crafted this because they had a 121 coming in, and they decided to expand this. They did not decide to expand it to every air carrier. Anyone who's just some sort of air carrier therefore can purchase or use equipment tax exempt. They did not choose to do that. They chose to have three categories under which operators could acquire an exemption. And in this case, Papillon has now acquired a certificate of convenience and necessity. So from that point on, they now qualify under the exemption. But during the audit period, they did not have that. And because of that, they simply do not qualify. If you have any further questions, otherwise, Your Honor, we think this is a very simple case. We think the legislative intent is clear on the face of the statute. When they reference 14 CFR 121, a taxpayer has to show to qualify under that they've got a certificate under 121. Thank you.
Very much.
Let's remove this to the federal court.
Judge Howe, you hit it on the head with the question of what is the definition of a supplemental air carrier. And Mr. Teasdale did his best to provide you with his definition of what a supplemental air carrier is. I submit to you that there is no way for Mr. Teasdale to respond to that with a citation. He cannot tell you, go check Arizona Revised Statute, blah, 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 there it is. He cannot tell you, go check this Part 119 definition, there it is. It's because it doesn't exist. And I understand that the Department of Revenue wants to define it as only operators using operation specifications under 121 and not 135, but there's absolutely no support for that in the legislative history. I believe that your question alone and Mr. Teasdale's response to that question establishes that these statutes cannot be determined to be plain and unambiguous. You have to look at the legislative history to figure out what the legislature was trying to do. Because after all, that's really the court's obligation here is, if the statute is not plain and unambiguous, the court needs to look to the legislative history to try to effectuate that intent. Mr. Teasdale started out by saying that the exemptions apply to a holder of a supplemental air carrier certificate under 14 CFR Part 121. If that's the case, then this applies to nobody, because there is nobody who walks the face of the planet who has a supplemental air carrier certificate under 14 CFR Part 121. All air carrier certificates are issued under Part 119. The only thing you get from Part 121 are operation specifications. The only thing you get from Part 135 are operation specifications. You don't get air carrier certificates. And there's no indication in the actual plain language of the statute or in the legislative history that the operation specifications were to determine the applicability of this exemption.
So to get a certificate under 119, you practically have to meet whatever the requirements under 121 or 135.
You have to explain to the FAA what you plan on doing, what kind of operation you plan on conducting, and you work with the FAA to establish which operation specifications you will operate under. And Mr. Teasdale tried to divide them by saying 121 deals with scheduled service, 135 deals with charter service. That's not accurate. The difference between 121 and 135 is the size and type of aircraft. That's it. You can do on-demand service under 121 if you're using large aircraft. You can do scheduled service under 135 if you're using a helicopter. Not a lot of people use helicopters for scheduled service, but you could. It really depends on what you intend to do with your aircraft. And so, yes, your certificate, which is issued under Part 119, would lay out which operation specifications you have agreed to operate under. That's why Mr. Teasdale is pointing out that in the CPCN that was later obtained by my client, the FAA said, hey, if you obtain larger aircraft, you're going to need to come back to us, because then your operation specifications may be set forth under 121. But again, there's nothing in the statute that indicates that the applicability of the exemptions depend on the size or type of aircraft you're utilizing.
Well, but can't you read the statute as saying that, and I don't dispute that you get your certificate under 119, but can't you read the statute as saying you have to meet the certificate depends on meeting the operational requirements under 121 or 135 or whatever other provision out there.
That's certainly the way the department would like you to read the statute. We have provided the court with case law from other jurisdictions. We couldn't find anything in Arizona that went into grammatical construction in statutes, and the fact that language that is included in a parenthetical is meant to be set off from the actual text of the statute. It's not to control the statute. And I want you to think about this. To accept that interpretation, the interpretation advanced by the division, you would basically have to eliminate the language supplemental air carrier certificate under federal aviation regulations and just take the language out of the parenthetical, move it over, and replace it. I mean, if the legislature really if the legislature cared about the size and type of aircraft you were using, why wouldn't it just say a person with operating under specifications set forth under 14 CFR Part 121? I mean, you have to ignore the language supplemental air carrier certificate under federal aviation regulations to come to that conclusion. And I want to get back to that point. Mr. Teasdale, he's represented to this court that Part 135 deals with on-demand, Part 121 deals with schedule. That's an overly simplistic reading of the statute, of the regulations. And again, really what matters is the size and type of the aircraft, and I directed the court to this previously, but 14 CFR 119.21 sub C makes it clear that a person who would normally qualify for operation specifications under Part 135, which what Mr. Teasdale says is on demand, can request that the administrator actually give them operation specifications under Part 121. These are interchangeable. It is not, the operation specifications were never meant to be used to determine the taxability of a purchase of dynamic aircraft equipment. They're basically operational guidelines that the FAA says, we're going to give you a certificate to operate, but you need to agree you're going to follow these. Whether it's 135, 121, you just need to consult us so you know what guidelines you're under. And if you're going to buy bigger aircraft, and that's going to be a change of your operations, you need to come back and talk to us. That's the whole purpose of it. But it's inaccurate to say that an on-demand operator is always going to be under 135, and a scheduled operator is always going to be under 131. And the last thing, if you actually look at the Airline Deregulation Act, it actually ends with the sentence, any reference in any law, rule, regulation, or document of the United States to a supplemental air carrier or supplemental air transportation shall be deemed to be a reference to a charter air carrier or charter air transportation, respectively. And I understand this is not controlling in Arizona. We're not talking about application of federal law. But the reality is, this is what I'm talking about, the fact that supplemental air carrier is charter air service. So, thank you.
Thank you very much for your arguments. We will take the matter under advisement and issue a ruling in due course. And with that, we are adjourned. Thank you.